Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we take a closer look at the war exclusion, a topic which is getting a lot of attention now that tensions are rising between Russia and the Ukraine. Now, most cyber policies contain an exclusion for war, but with a carve back for what has come to be known as cyber terrorism, which is basically the actions of a non-state actor seeking to advance some political, religious, or ideological objectives. Sounds straightforward enough, but the application of the war exclusion to a real-world cyber claim is challenging. There are problems of attribution, or simply put, whodunit. There's the dynamic of many insureds being collateral damage rather than the intended target of the attack. And whether there must be a kinetic component to the warlike actions remains an open question. And truth be told, the case law on how this exclusion should be interpreted under a cyber policy is scant, some would say non-existent. But that hasn't stopped commentators from trying to read the tea leaves by looking at how courts have ruled in coverage disputes centered around other policies being tapped for a cyber loss. In one such case, a New Jersey trial court recently ruled that an exclusion for losses arising from war and hostile acts did not apply to losses sustained by a pharmaceutical company stemming from a 2017 cyber attack. The insured's computer systems were infected by malware causing more than $1.4 billion in damage. The insured had purchased a property policy intended to cover all risks, including the destruction or corruption of computer data or software. However, the insurers argued that an exclusion for hostile or warlike action applied to the loss. In ruling for the insured, the court looked to the plain meaning of the exclusion. The judge stated that the insured had a reasonable expectation that the exclusion would only apply to traditional forms of warfare, and further noted that the insurers had failed to put the insured on notice of their intention to exclude cyber attacks. Now, while this is welcome news for this particular insured, please keep in mind that the decision of a state trial court judge is hardly precedent-setting. Other courts may rule differently, and other policies may contain stronger exclusionary wording. This is yet another example of a claim triggering so-called silent cyber coverage under a policy that was never really designed for that purpose, and underwriters can be expected to revisit existing language in light of this decision. The takeaway for our viewers is that you'll want the war exclusion on your cyber policy to be crafted as narrowly as possible. If not limited to declared war, then at least not so open-ended as to eviscerate the coverage under a range of civil disruptions. Now please note, this is intended as general information and guidance, and you'll want to consult with a qualified insurance broker about your specific coverage needs. If you're interested in more great content like this, you'll want to subscribe to our Executive Liability newsletter, which covers the latest legal and regulatory developments not only in cyber, but across the full spectrum of specialty line coverages. For more information, you can DM me on LinkedIn or email me at david.finz, that's david.finz, @alliant.com. And we'll keep you up to date with podcasts, white papers, and other great content we offer to help you find the more rewarding way to manage risk. Thanks for watching.